Hi everybody, this is Jenna Fasula-Lapierre from the Miller Elder Law Firm. I'm an associate attorney here and chief executive officer, and I wanted to just take a moment here today and talk about pre-planning for incapacity, which put in a different way is putting estate planning documents in place for the purposes of avoiding a guardianship in the future. So let's talk about what is a guardianship, high level. A guardianship is, it's a very effective tool and it's an important tool, and, we're glad to have that tool in Florida when the need arises. However, with a guardianship comes an adjudication of incapacity, which means a judge is going to come in and take away the rights of the individual, the alleged incapacitated person, and put in a legal guardian in place to oversee those rights. The removal of those rights can include the right to vote, the right to drive, the right to determine residence, the right to contract, the right to marry, to name a few. So the process is great when we have no other options. However, if we are speaking to clients and we're pre-crisis and we've got somebody coming to us with capacity, our guidance is always going to be, let's get really solid, good estate planning documents in place to avoid the need for a guardianship in the future. And so what are those documents? Number one, it's going to be a really good durable power of attorney. Not all durable powers of attorney are created equal. It really comes down to how they are drafted, the specific items or authorities that are contained within the document, and how the document is executed. So just because somebody has one doesn't mean that that's going to comply with Florida law at this juncture, or that institutions are necessarily going to accept those. So really important, if you have a durable power of attorney, please ensure that it gets reviewed by an attorney in present date to make sure it's valid. And if you don't have a durable power of attorney, please ensure that that's on your radar to kind of start pre-planning and making sure we don't have to ever get to a guardianship. A durable power of attorney covers all things in someone's financial house. So nothing to do with healthcare matters. We're talking about real estate decisions, banking transactions, anything in the financial house. Conversely, the other kind of component to a guardianship can also be decisions over the person, meaning healthcare decisions, decisions about accessing medical information, and consenting to procedures, whether those be life-saving or also, the removal of life-sustaining measures. And that's going to be through a healthcare surrogate and through a living will. Those are the two documents that are going to be critical to ensuring that the person during a time of incapacity or otherwise is going to have the authority to help make decisions. Both of those documents don't actually wait for incapacity. They are signed and effective at the moment that they are signed with an attorney, but those documents going forward will withstand incapacity and remove the need, hopefully, for a guardianship. So anyways, durable power of attorney, healthcare surrogate, living will. Make sure you have those documents, make sure they're legally valid, and hopefully that will give you and your family the peace of mind to be empowered to make the decisions that you need to thrive and take care for the rest of your life.